Hi everybody. Um, Today I've brought three of my lovely consultants at Woodstock together to talk about the subject of relationships and cohabiting and the legal impact it may have. I've got Becci, who's in private client up there, Amy Langlois, who is a family lawyer, and Zoe James, who is a property lawyer. And we wanted to do this because there's lots of occasions when the issue of cohabiting and the legal implications actually bring all three of these services, disciplines, and areas of law together. So I thought it'd be really useful to get the girls together and answer some typical scenarios that we see quite commonly, and to get some answers for you. So yeah, you know where to go when you need some advice, and to give you an initial steer. So let's start, shall we? We've got three scenarios. First one. My boyfriend and I want to buy a flat together. He's putting in the deposit and then we are splitting everything equally. Do we need to do anything? So who should we go to first? Who wants to start? Family, property or private client? What's your 2 pence worth on this one?
Should we go
Shall I
family?
start? Oh, you go family. Go family first.
So if if the boyfriend, for example, came to me, I would suggest that they enter into a cohabitation agreement to record their cohabitation arrangements. So in terms of how their bills are paid, how mortgage is paid, and also what would happen in the event of separation. It just makes it cleaner when they do decide to go their separate ways, if they choose to do so in the future. If not, then at least you're protected in the worst case scenario. So that would be my advice to any parties entering into cohabitation together.
And it's, I guess, it's the last thing you think about, is it? Because you're in that sort of dreamy, nice stage, you're all moving in together. But it is really important people protect themselves. And I've seen friends that have had real difficulties after. And it's probably one of those things that stays much like a will, Becci, on people's to-do list with this sort of situation. I need to sort that. And they know in the back of their mind they probably need to sort it. Is it a big job? Is it an expensive job? Is it something that can be done quite quickly and easily?
For cohabitation?
Yeah, the agreement.
It can be done very quickly. It would be best if both parties obtain independent legal advice.
Yeah.
Although such agreement isn't legally binding in this country, it does add great weight if anything was to happen later on in the line. Without an agreement, then you're fighting against each other, and it would cost much more and likely to be much more acrimonious.
And I guess as well, it's nice from a relationship point of view because you both know where you stand. So,
Exactly.
You set it out from the start. Anyone else? Should I go to you next, Becci?
Yeah, so for me, just highlighting the point really to them both that unfortunately, as the law stands in Wales at the moment, cohabitees still have no legal rights. So it is hugely important, especially if you want to give the other the right to continue living in that property. You don't necessarily have to give it to them by your will, but you can give them a right to continue living in that property after one of you were to pass away. If there is no will and you own the property as tenants in common, I'll let Zoe explain that bit. Then effectively, whoever your assets were to go to by the rules of intestacy, which apply when a person doesn't have a will, could effectively kick out the surviving cohabitee from the property and force the sale. So it's hugely important that you get that will in place. And I can act for both parties there. So I can do mirror wills or individual wills for both. And it's a really straightforward, simple process that we can get done. So.
And I guess, when you first move in, you don't really think about these things, but perhaps, further down the line, things get more serious, children come along, that sort of thing, it becomes, so much more important.
Absolutely, yeah. And if you're even thinking about marriage or things like that, children, that's all applicable to wills as well. Marriage revokes a will. So you can write your will in contemplation of marriage if it is imminent, although that's always a little bit of an awkward conversation with everyone in the room together. But we can write it in contemplation of marriage so it isn't revoked by a future marriage. And if children are on the cards as well, then we could look to talk about guardians that can be appointed by your will as well. So yeah, it's definitely worthwhile having a chat if you're thinking about moving in together.
And what about from your perspective, Zoe?
Yeah, from my perspective, really, probably similar to sort of Amy, we could have a declaration of trust drawn up between the parties, which would state sort of how you wish to hold, well, obviously holding the property, but also how you wish to split sort of the various sort of money. So say, for example, Mr. was putting all the deposit in, maybe like £50,000. We could draw something up which states that actually that first £50,000 could be payable back to Mr. and anything else could be split how they agree. So
Yeah,
there's definitely things in place that we can do as well from property perspective, and have sort of a restriction on the title so that they know the declaration of trust in place. So yeah, sort of similar to Amy, also get that declaration of trust in place as well. It just protects everybody, and again, everybody then knows sort of where they stand if there is a separation, and you just got it written down, and then you know exactly where you are and how it's going to be dealt with on the sale of the property.
Yeah, no nasty surprises further down the line, which, you know, don't leave a good taste in anyone's mouth, do they, for either party. So, and, you know, as a litigator, stick their 10 pence worth in, you know, none of, you know, and Amy will say it's, you know, it can be expensive, it can be drawn out to, you know, argue over those things. So it is much better to get it sorted beforehand. Okay, so the next one we've got, this is the further down the line, a bit more doom and gloom, I think, after the honeymoon period. My husband and I have separated, but it's very amicable. He has moved out and I think the house is too big for me now. Should I speak to a solicitor about splitting the money, sorting the money, the house? Who wants to go first on this one?
Shall we start with me?
They're divorcing. Let's go with the family lawyer.
Yeah.
You're probably the
Get
first
me out
port
the
of
way.
call.
Yeah.
So yes, get advice early before anything happens. So before you're implementing any agreement that you've reached together, I would strongly advise the parties to enter into financial consent order. So a financial consent order will record what the parties have agreed in relation to their matrimonial pot. This deals with assets and also liabilities. But in order for a court to look at a financial consent order, which is done in the background if it's by agreement, you have to have started divorce proceedings. So divorce needs to be up and running. You have to have reached the first stage of divorce before a court will entertain looking at the financial agreement you've reached. But that financial consent order, once approved by a court, is the only legally binding document that will separate your financial ties. Without that financial consent order approved by a court, you're both financially tied to each other, even if you are divorced. So that is the most important document to have if you are going to be separating from your husband, wife, or civil partner.
Is there a requirement to get independent legal advice on the consent order? And will the court look at it if they think it looks unfair? For example, I'm just thinking if one party managed to persuade somebody else to sign up to something and they haven't gone and got independent legal advice, and then the court looks at it and think that looks incredibly unfair, something's not right here.
So unfortunately, you don't have to get independent legal advice. So both parties can do it all unrepresented, or one can choose to get a solicitor to draw it all up and then the other one not represented. However, ultimately, even though it's an agreement you've both reached, supposedly reached together, ultimately it's the court who decides whether or not it's an agreement that they deem as fair. With the financial consent order, the court also asks for a brief summary of the parties' financial situation. That's recorded on a statement of information form, and just with that basic information, the courts will decide whether or not they want to approve the order. If they're not happy with the agreement that's been reached, they will ask questions. So it's not strictly, so the courts won't just accept it just because you've forwarded an agreement that's been signed by both parties. The courts ultimately have the last say. Yeah. But that's good because it can protect those that are potentially forced to sign something that they don't know what they're signing. Yeah, I think that's really reassuring, and they're obviously seeing a lot of consent orders, so they know what ultimately looks right and what looks slightly wrong. So yeah, I think that's really comforting. Who should I go to next, Zoe? Just mix it up a little bit.
Yeah, I mean, from my point of view, obviously it's probably going to be sort of more Amy initially dealing with getting all the financial elements in place, and then when they are at a position that they've made an agreement, obviously it then be coming to sort of a property lawyer like myself, and then we could then deal with the sale of the property and the conveyancing element of that. Obviously, if they're looking to purchase a property as well separately, we could all tie it all in, so there's always that options. So yeah, we would be able to deal with the sale at the end once the agreement's all been reached.
Okay, and Becky, from your perspective?
Yeah, mine's interestingly, actually, I said earlier that marriage revokes a will. Divorce doesn't revoke a will, but it does treat the ex-spouse as being predeceased, rightly or wrongly. I would still suggest reviewing your will, because if things are really amicable, again, I mentioned earlier, you can still give the right to things. And if it's really amicable, I mean, personally, my parents are separated, but it's a very amicable situation, and they probably would still afford each other the right to enjoy their estate if they were to die, with a protection for the children ultimately. So there are options to look at. If you do want to disqualify him from any entitlement, whilst you are still married, he is still in the category of persons as your spouse that could claim against your estate. So there's things like statement for the purposes of the Inheritance Act that I would talk to the individual during that process as well, to just act as a defence to any claim that might come up.
Okay. Do you know what? This is a bit of a curveball question. It's because I was discussing this with some friends today, and someone made the comment about never be the one to move out. And we've got this scenario where she's remained in the house. I'd love to hear your perspective on that one, Amy. Is it should you refuse to leave? I'm just curious,
So my advice would be, once you've moved out, one of you have moved out, it just makes it much easier for the other one to stay there and not do anything.
Yeah.
If children are involved, yes, it's going to create tension. It's going to create potentially animosity and not great atmosphere for the children. However, if one of you decides to move out for whatever reason, it just means that getting the other one to come to an agreement regarding finances could be that much harder, because you've removed yourself from that negative atmosphere.
To do it.
Exactly. Yeah. And this is also why, before people go to sell their homes, I would always say to get a financial consent order recorded and sent off to court, because once that asset's been sold, there's no incentive for anyone to do anything, but you're still financially tied.
Yeah.
And also, if you move out, you don't know what they're doing to the property. If you've come to an agreement that, agents will come round to look at the property for potential buyers, there's nothing making the person who stayed there allowing the agents to come in.
Yeah.
They just can make it really difficult. They could, trash the house, all those things.
Yeah. Okay. Really useful.
Carly, can I just say your friend needs to update her will? Just saying.
It's not a true friend. My friend's husbands, if they're watching this on LinkedIn, will be you want to be a friend? We were just talking about a scenario.
Okay. Sure.
Last one. So this is, and I think this happens loads, and I have had friends that have, had to deal with this one, where one of you owns the property. In fact, I did this to my husband, but I'm still here. It's okay. Owns the property. They're living in it. The other one has a property or may not have a property, sells that, has their funds, and then moves in with their partner into the property that they own. And may say, I'm going to contribute to mortgages, bills, you pay for holidays, and you live as a married couple, but the title's in one person's name, the other person sold their property and have used the funds to do something. So that's a really common situation, I think, and can get quite complicated. Who wants to go first on that one?
Shall I go first? Because mine's quite straightforward. Do you will. Because the other thing I would talk about is depending on the ages of the individuals as well. Because if they've got sort of one person with a lot of cash assets and one person with the property in their sole name, if any sort of continued costs moving forward might be applicable, care costs or something like that, they could be putting themselves at risk of if one cohabitee lives in the property and the other doesn't have any right to it, that could be fully consumed. So depending on the age, I would start talking about trusts and things like that in the wills. But ultimately, it is get your wills sorted so they reflect if one person's got, say £1 million of assets and they want some of it to go elsewhere, the other person's got, say, a property worth 250,000, bear in mind that split asset, and if you want to reflect that in the wishes of the will. So just basically get your wills done would be my advice on that one. So.
You've just really highlighted a really important point, and maybe Amy will pick up on this, because you sort of think that this is a sort of our generation problem, but actually what you've highlighted is it's an older generation issue as well. The people that are you know, finding new partners after divorce, older in years, and actually there's probably more at stake at that stage, you know.
Second marriages with children from previous relationships, things like that, all relevant to your wills. So yeah, absolutely.
Yeah. Amy, should we go to you next on that one?
Yeah. So depending on whether they're getting married shortly, then I would advise to draw up a prenuptial agreement or a postnuptial agreement. Reason why date of marriage is important is because if we don't have enough time before marriage, a prenuptial won't work. We have to give at least around a month for the parties to think about it and not feel coerced. Otherwise, they could argue later down the line. So depending when date of marriage is, one of the nuptial agreements to reflect the difference in who's put in what and who's got what assets, liabilities, what's in their savings, etc., and then what would happen in the event that they were to separate. However, this isn't a one for all, so these agreements have to be updated. So as we go on in life, they might have children, they might one might decide that they want to give up work. When certain events happen, you need to update the agreement so that it reflects their current wishes. If you don't, it's not you know the worst thing that could happen, because you have got an agreement in place. But if you don't update it, then the current agreement will stand. But children can change things. So if parties were to have children after the agreement's been drawn up, they should look to review it.
Okay. And a postnup, talk me through that a little bit. I think everyone always hears about prenups. Everyone knows what it is. What's a postnup? I could take a wild guess at what it is, but we'll let the expert explain.
So postnup is similar to prenup, but it's done after marriage.
Yeah.
For whatever reason, they may not have known about a prenup prior to getting married, or they just left it too late. So a postnup essentially does what a prenup does, but it's done after the date of marriage. And it may be that after they got married, one of them came into a lot of inheritance, for example, and they just wanted to protect it. So, you know, so for some parties, that's when they would get a postnup. They aren't, unfortunately, legally binding in this country. However, again, like cohabitation agreement, they do add great weight. And if they've been drafted up correctly by qualified lawyers, then they stand a great chance of a court following that agreement if it came to divorce at a later stage and the parties issued financial court proceedings.
And what if you do none of that and you do contribute to the mortgage and the bills? Then where do you stand? I mean, it's interesting from both perspectives. You know, if you allow someone to do that, where do they stand? And that might sort of pass on to Zoe a little bit.
So from family point of view, if, for example, they've been married 15, 20 years and they decide to go down the route of divorce, because of the length of marriage, it's considered a long marriage in the eyes of the law. And the starting question a court would put to the parties is, why should there not be split of the assets and liabilities 50-50? And then there's a number of factors the courts will look at before they decide what the outcome should be. But without a prenup or a postnup, then, you know, why shouldn't it be 50-50?
Yeah. And what if you don't marry?
If you don't get married, then it won't be me that you'll be coming to see, because unfortunately cohabitees aren't afforded the same rights as married couples. So it makes it cleaner, but it will go down the route of dispute litigation instead. So still costly, and can, you know, cost you quite a bit of money to sort it out properly. So you're better having an agreement drawn up when you're both amicable and happy.
Yeah, makes sense. You got anything to add, Zoe, to that one?
I mean, I guess the only other thing to say is obviously a case of the couple really deciding how they actually want to hold that property as well, whether they potentially do both want to be on the title. And obviously, from my point of view, we could then do sort of a transfer of equity, possibly remortgage. You'd need to speak to the mortgage lender to sort of get consent, and there's potential stamp duty issues as well on taking over mortgage debts. So it's just sort of really deciding how they want to sort of hold the property, whether they do want it in both names, maybe taking some tax advice. And then, yeah, if they need anything changed in terms of property title, then we could look at that from our end. And again, sort of put declarations of trust in place if they do want that. So that's it's more really sort of Amy and Becky's probably won this one. But yeah, if they do need anything done further down the line, then yeah, that's something we can assist with from a property point of view.
And I suppose the scenario we had was that they'd be moving in with their partner and would sell their property. If they didn't sell that property, they would be, and they did decide to go on the title for this one, they would be acquiring a second property. So stamp the extra stamp duty, land tax payable. So there's all of those sorts of things to consider when you're taking that leap.
And then I suppose if they went on the title before they sold their own, there's capital gains tax implications as well.
Yeah, so definitely need tax advice in relation to all of this as well. So
Well, it kills the fun, doesn't it? But but that is really, really useful. And I think it's just, it seems to be the running theme is when you're making these sort of big life moves, life decisions, is to get early advice and make sure, you're on top of it and agree things and get things written down early to avoid any disputes later down the line. And it's not the most romantic of things, is it? But, and I know full well that it stays on people's to-do list, but it sounds like, there's numerous reasons to deal with it early and to get things down on paper.
Absolutely, yeah,
brilliant. Thank you. So obviously this is on going to be popped on LinkedIn. So if you've got any questions, then pop them in the comments below. Or if you're more comfortable direct messaging the girls, they're tagged on here. So connect with them and direct message them, or myself. Or call the office if if you want to have if you've got something more in depth, you need to book an appointment to have a conversation with them. But our doors are always open. Happy to answer your questions, and thank you for listening. And thank you girls for sharing your wisdom.
Thank you very much.
See you later. Thank you very much. Bye bye.